Preston Hemphill is, I believe, the sixth Memphis police officer to be terminated for his involvement in the Tyre Nichols killing. I have received the full package of his decertification documents. I'm going to go through that here. Now, I know some of you have been wondering why I haven't covered this one with the other officers, the other 5 officers. Well, it's because those packages were released separately. I received the first set of packages, the first set of documents for the 5 officers, and then this was released, I guess, separate. I don't know what was going on with that, why that was separate, but I now have them and we're going to take a look at them. Yeah. This is 18 pages. It pretty much includes the same documents that we saw for the other 5 officers. And I think I've only really gone through completely the decertification package for former officer Demetrius Haley. I do want to take a look at the other packages too, and then also break down some of the information that are in some of these packages. Okay, so first of all, this is going to the Tennessee Peace Officer Standards and Training Commission. This is the change of status from the Memphis Police Department. Now, this goes over when Preston Hemphill was terminated. So you'll see the effective date of that termination was February 3rd. Let's scroll further down. You'll see the signature there by the head of the Memphis Police Department. Then you have the change of status here that references the leave from January 8th, and that was prior to the termination that was in February. And then you have the decertification request. Down here under 3, it says suspended or discharged 30 days or longer, resign in lieu of termination, resign with disciplinary action pending that could have resulted in termination, or discharged by his or her employing law enforcement agency for disciplinary reasons. I'm actually going to stop here for a second because I want to point something out with this that I had not pointed out before. It's really important to take a look at what this language actually says. Sometimes we worry that people are able to leave a position and there's no follow-up action to let people know that they were not a good officer at the previous employer that they had, and that now they're just going to move on and somebody else is going to hire them, not necessarily knowing that this other agency was getting ready to possibly suspend or terminate them. If you actually look at this language, you'll see that they really can't get around that, because if this decertification request is submitted, then this number 3 can be checked. And it says here, so if a person tries to resign to cover themselves so that they aren't getting decertified, well, that doesn't necessarily make it so that the agency can't decertify them. It says right here, suspended or discharged 30 days or longer, resign in lieu of termination. Okay, that's the person saying, I'm going to resign and try to get a job someplace else, and I'm going to still be certified. But no, an agency can decertify them before that. And then you have resign with disciplinary action pending that could have resulted in termination. So it's not just that a person got terminated and then got decertified. It could be that a person tries to leave and go to another job, resigns so that they can maybe find another job without this current employer decertifying them. Not if this is checked. Not if this is checked. So that's what they've checked in this case. All right, let me go further now. And that was February 8th. Statement of the charges. And as you see there, he was a part of the OCU Scorpion Team 1. Notice is hereby given that you are being charged with violations of policy, law, or regulations as shown below. DR 104, personal conduct termination. DR 101, compliance with regulations to wit weapons, which would be a 40-day suspension. DR 108, truthfulness termination. DR 101, uniforms. This actually had to do with his handcuffs, but we'll get to that. 30-day suspension. and DR 130, inventory and processing of recovered property, 30-day suspension. I believe that had to do with Mr. Nichols' cell phone. Date of the occurrence, January 7th, 2023. Now let's get into the statement of particulars. And if some of you have seen video one, then you're familiar with some of the statements that are shown here in this first paragraph. On January 7th, 2023, you and two of your partners conducted a traffic stop involving a suspected reckless driver at Rains and Ross, who later died of injuries sustained during the incident. The subject was removed from the vehicle by you and your partners during a confrontation while on top of the subject. Audio from a body-worn camera captured you using the assaulted statement, "Get on the effing ground, finna tase your A." The subject was not using profanity or showed signs of violence towards you. The subject ran away from officers on foot. The subject ran away from officers on foot down Ross. A second set of officers caught the subject at a different location while you remained with the vehicle. You can be heard on body camera telling your partner, "I hope they stomp his A." Digital evidence of your actions will shed a negative light on the Memphis Police Department. Your behavior was unprofessional and unbecoming of a sworn public servant. Your actions place you in violation of DR 104, personal conduct, which states, and this is the actual personal conduct policy that they are saying he violated. Let me stop just for a second there, because I have seen that particular video. It's interesting because I did not realize he was on top of them. So that's some additional information. If you've seen these videos, it's hard to sometimes figure out what's going on. It is dark. I believe it's maybe 8:30 at night, 8:30 in the evening. So it's dark outside. It's hard to see what's going on with this confrontation. You can see some things. Some things are definitely clear. It may not have been clear that he was actually on top of Mr. Nichols. That is what it states in this document. Let's keep going. Then we have, you and your partners removed the subject from the vehicle and used physical force to detain him. You took out your city-issued conducted energy weapon, Taser, from the holster and placed it on the subject's leg. After the subject was pepper sprayed on the ground by your partner, the subject got up and appeared to attempt to distance himself. You deployed your Taser for 3 seconds while the subject was on his feet and running in motion from you. The subject was not armed and did not impose an immediate threat to you or others. The subject was also in the middle of the street while traffic was still present when you deployed the Taser. You put everyone involved at risk of serious bodily injuries due to oncoming traffic. It was unknown if the Taser made a physical contact with the subject, but one prong was missing upon your inspection of the cartridge. You performed no further action to locate the missing probe. You have been certified to carry the CEW since September 16, 2022. Therefore, this places you in violation of DR 101, compliance with regulations, to wit, weapons, which states in part. And so here is the policy for the Taser, and they've got the definitions listed here. So first of all, they've got less lethal force. Force applies with the intention to subdue or render a subject non-threatening. This may be part of the reason that they quoted up here, he was not threatening you. He had not, there was this part where he's running from you. It says in running motion from you. And then down here under definitions where it talks about less lethal force, it does talk about rendering a subject non-threatening, but it sounds like this subject was already non-threatening. Talks about the different modes that you can operate it in. All right. CEW shall not be used. This may be the part that's most important. The CEW shall not be used, A, in a punitive, relating to, involving, or intending to inflict punishment, or coercive manner, in drive stun mode for pain compliance to prod or escort persons, on a handcuffed or secured individual absent an overly combative behavior that may cause harm to the officer or others and that cannot be reasonably dealt with in any other less obtrusive manner. D, solely as a compliance technique to overcome passive resistance or on any individual who does not demonstrate an overt intention to use violence or force against the officer or another person. I don't know if you can see this here, but D does appear to be in bold, a little bit darker. So it may be that they're trying to say that this particular one was the one that he violated. Remember, it's saying the CEW shall not be used when in these situations. And they were saying, I believe, since it's bold, that this was one of the ones that he violated. It also can't be used to rouse an unconscious or intoxicated or impaired person on persons running or fleeing. Remember when I said up here, what did I say up here at the very top, where they said he was running from, it says right here, subject, you deployed your taser for 3 seconds while the subject was on his feet and running and in running motion from you. The subject was not armed and did not impose an immediate threat to you or others. So when you go down here and take a look at where it says the CEW shall not be used, it says right here, on persons running or fleeing. That is in bold, it appears. For any purpose of horseplay or curiosity exposure. Then this last one, in any environment where the officer knows that a potentially flammable, volatile, or explosive material is present. That is in bold also. So it appears that those are the three reasons why they're saying he violated this policy in the way that he used and how he used his taser. You were required to complete a response to resistance form of a true account of the incident on January 7, 2023. In your statement, you said the subject attempted to grab your partner's duty weapon. There is no video footage to corroborate that statement. You then provided a conflicting statement to ISB investigators and said you did not see the subject grab your partner's gun. You also said the subject fought you and your partner. Video evidence showed the subject running away from you while you attempted to grab him. The subject was thrown to the ground by your partner and ran from the scene at Rains and Ross. During your Garrity statement, you were afforded the opportunity to review your use of force narrative and told ISB investigators that the details were correct. Your statements were inconsistent and untruthful, and you documented false statements. Your actions place you in violation of DR 108 truthfulness, which states a member shall not give any information, either oral or written, in connection with any assignment or investigation that is either knowingly incorrect, false, or deceitful. Again, there was the footage there that showed him running away and the officer attempting to grab him. They're saying here that there was no video footage to corroborate this statement about Mr. Nichols trying to grab Officer Hemphill's duty weapon. Next, they say you did not have your city issued handcuffs during the incident. Upon inspection of your equipment, you provided 2 sets of handcuffs that you personally owned. Your MPD handcuffs were not in your possession on January 7, 2023. You are required to carry and be responsible for all city equipment issued to you. You are in violation of DR 101, compliance with regulations to wit, and it speaks to issued equipment, handcuffs, page 7, which states in part. Let's go down here to the equipment. Members shall only carry equipment and other items that have been issued by the department or approved by the Chief of Police Services. So you have here what they're saying is you can't you can't be out here carrying this other equipment. It says the department issues the Peerless Model 801 hinged handcuff in a nickel finish with a handcuff key. Officers shall carry their department issued Peerless hinged handcuffs while on duty. Officers may purchase and carry a second set of department approved hinged or standard link chain handcuffs. The handcuffs shall be similar in color, silver tone finish, to the current department issued handcuffs. The department issued key shall be capable of unlocking the secondary handcuffs. A maximum of 2 sets of cuffs shall be carried on the duty belt. This is one of those things that had me asking more questions. I did do an entirely separate video that talked about the missing handcuffs that the department gave him. Where were they? Why did he not have them on him? Why did he have these other 2 handcuffs on him? What kind of handcuffs were they? And what was going on with this? There's just no information here about that at all. I suspect that the officer may not be inclined to give any more information because of the charges that are against him. So we probably won't find out that information for a while. Next up, you were instructed to complete an inventory and document items of monetary value on a Memphis Police tow-in slip. In your statement to ISB investigator, you admitted observing a cell phone in the driver's seat of the blue Nissan Sentra. You did not document the cell phone on the tow-in slip. The cell phone remained inside the vehicle upon its arrival at the city impound lot. You failed to tag the personal property into property and evidence. Your actions place you in violation of DR 130, inventory and processing recovered property, which states, all members shall properly inventory and process recovered, stolen property, evidence, found property, or personal property in conformance with departmental orders and directives. This regulation includes property and vehicles that are taken into police custody. Let me talk about this for a second. This can be a really big deal. It sounds like it's something minor. Oh, the cell phone was left in the seat. He neglected to fill out the proper forms and turn those forms in. The whole idea is you have a manifest, everything is documented, the person who received it, what time they received it, everything is in place. In a different sort of case, this could be a really big deal. So I see how for some people they might say, oh, well, he just left the cell phone. No, it's actually a really big deal here that the cell phone was not tagged and turned in according to policy. So then we have the signature here at the very end by the issuing officer, charging officer, and then Officer Hemphill's signature there. Was officer relieved of duty? Yes. Then we have the hearing form. And this hearing was held February 3rd, 2023, 10:15 in the morning, it looks like. And those were the people who were there. Again, this is the statement of the hearing officer. And these were the actions that were ordered for each of the policy charges against him. Personnel conduct sustained, termination is ordered. The weapons sustained and 40-day suspension is ordered. Truthfulness sustained and termination is ordered. Uniforms, which is really the handcuffs piece, sustained and 30-day suspension is ordered. And then the inventory and processing of recovered property, sustained and 30-day suspension is ordered. It did say down here that he had X'd the part that said will file a grievance. It says, I understand that by requesting the grievance procedure that I'm waiving my right to recourse through the internal or civil service commission appeal process. And most of this is listed here. I'm not going to read all that. But again, this is the same information that we went over initially, and it's just included now in the statement of the hearing officer. this piece about the personal conduct and what he said. And then you had the piece about the weapon, which had to do with the taser and him improperly using it against someone who was running away, and not to overcome passive resistance. I'm not sure about this environment that's potentially flammable. I think they may be concerned about the oncoming traffic. I'm not entirely sure. If some of you have more information about that, definitely let me know in the comments. And then you have the piece about the truthfulness, where he mentioned Mr. Nichols trying to take his partner's weapon. Then we have the piece about the missing handcuffs and him using his own handcuffs, and then the failure to process the cell phone. And it said, during the administrative hearing on February 3rd, Officer Hemphill was informed by the hearing officer that he is now afforded the opportunity to make a statement. Officer Hemphill responded, "No, sir, I don't have anything to say at this moment," indicating that he did not wish to make a statement. And then it said the MPA representative was asked if she would like to make a statement. And it says, and this is Lieutenant Cage Rosario, submitted a written statement which will be included in the administrative file. To whom it may concern, the Memphis Police Association objects to the Memphis Police Department's decision to proceed. And let me stop here for a second because I want to see if that's actually included in here as a separate document. I believe it is, but let's see. Yes. Okay. Nope. Okay. No. And the reason I'm scrolling back through this is because the other package for all of the other former Memphis officers, this was a separate letter by the Memphis Police Association that had been included. And I actually did a separate video on this. People were very upset about it, but I was just trying to get people to understand that they had submitted this letter and why they were saying what they were saying. I'm not trying to say I have support for it one way or the other. I'm just including it as it was included there. I thought it was worth people seeing it and understanding what was going on. So let me go back and read this now, because this is actually what the letter says. You can definitely go back to my video that says their side. That is where I go through all of those letters. You'll see all 5 of the letters for the other 5 officers that were in that package together. This is included in this one. So I'm just going to read it here in case you have not seen this letter yet. It says, to whom it may concern, the Memphis Police Association objects to the Memphis Police Department's decision to proceed with the administrative hearing, which they were going under process, for Officer Preston Hemphill prior to the conclusion of the TBI's investigation. Per Article 14 MOU, Memorandum of Understanding between the Memphis Police Association and the City of Memphis, a reasonable amount of time to review the statement of charges, including all proof to be relied upon by the hearing officer, is to be given to the representative prior to the administrative hearing. Upon review, several pieces of proof were omitted from the file. Statements from other principal and witness officers were not included in the file. This is only one example of the violations of this officer's right to due process. Not only is this a right under the MOU, but it is a right guaranteed by federal law. See Cleveland Board of Education versus Loudermill, where the court provided that a public employee with a property right to his or her employment must be provided notice of charges against them and a hearing to provide them with an opportunity to defend themselves against the charges against them. Additionally, that hearing must be a meaningful one. See Wagner v. City of Memphis. In Wagner, Mayor Henrington predetermined the outcome of the hearing, and the court said there was no due process. This will serve as the MPA's statement for this administrative hearing. In the other video that I did about these letters that were submitted on the officer's behalf by the Memphis Police Association, I had never heard of the Memphis Police Association. One of the things I did in the video was to actually go to the website so that we could see who the Memphis Police Association was. I had never heard of them before, but I had an idea of who they were and what they did. But if you go to that video, then you can see what's on that website, or you can look it up yourself. I then went through that letter, as I mentioned before, and talked in the end about how you put cases in a letter. I basically talked about it from an employment law standard, not necessarily, again, in support of any position that they're trying to take here. All right, let's pop back over and see what is left on this. We're down to page 14, just a couple pages left. Hearing officer convened the hearing at 10 o'clock without rendering a decision, reconvened the same day, later in the day. And those parties were in attendance. So in conclusion, the hearing officer carefully reviewed all documents related to each alleged violation of the listed DRs by Officer Hemphill, including the Garrity statements of all the charged officers and the response to resistance forms. The Garrity statement made by you and the other officers, charged officers, are not consistent with each other and are not consistent with the publicly known injuries and death of Mr. Nichols. Hearing officer additionally consider the written statement submitted by Lieutenant Cage Rosario. That was the letter that I just read you. The hearing officer states, in this instance, Officer Hemphill was served with the statement of charges before 10 a.m. on January 30th, 2023. Lieutenant Cage Rosario contacted Memphis Police Department on February 1st, 2023 at 5:48 p.m. requesting to review the administrative file, and arrangements were made for 1 p.m. the next day. The next day, an event occurred and Lieutenant Cage Rosario was unavailable, and the review was rescheduled for the morning of February 3rd, 2023, at which time the representative was able to review the ISB file. Additionally, the body-worn camera footage relied upon herein was available publicly as of January 27th, 2023. All right, so for each of these, the hearing officer pretty much agreed with what had originally been decided, and you'll see that here. Termination is ordered, charges sustained, 40-day suspension is ordered, charges sustained, termination is ordered, charges sustained, 30-day suspension is ordered. And then for the last one, charges sustained, 30-day suspension is ordered. And then you have the memorandum here with all of that same information there. And then you have City of Memphis. And this is the last part here that goes over all of it. It says you have 10 calendar days after receipt of written notification of the action taken in the file to appeal with the Civil Service Commission. You may file your request for a civil service hearing in person or by mail to the following. And that's it. That pretty much goes over that set of documents that had been released from the city of Memphis regarding the actions taken with former Memphis police officer Preston Hemphill. That goes a little bit more into detail. If you've seen the video, now you have the actual document in front of you that lays out what his statements were, what he actually did, which policies he violated, and especially, I think, the use of the taser that really broke down his action versus what the policy said. And you can see directly why they said he violated that policy. So I hope this provides you with some additional understanding of what happened with his charges and his termination. And if so, go ahead and give the video a thumbs up and don't forget to subscribe. Peace.